Welcome to The Insurance Lawyer, the podcast where we discuss topics concerning claims and lawsuits between insurance companies and their policyholders. I'm your host, Evan Schwartz, founding partner of Schwartz, Conroy & Hack. The firm represents business and individual insurance policyholders in claims and lawsuits against their insurance companies, helping policyholders get their claims paid. Today, we're going to begin an edition of what I call Trial Stories, and I'm pleased to have my partner, Matt Conroy here, who is both the trial partner of the firm and is also the partner in charge of the business or commercial insurance recovery unit of the firm. Welcome, Matt. So today we're going to talk about a case that we handled not too far in the distant past, and that case involved a number of really interesting insurance recovery issues. And Matt was the attorney that was primarily responsible for all of the issues that surrounded the clients and tried the case. Matt, tell us about this case.
Thank you, Evan. It's a very interesting case, especially from the perspective of multiple insurance policies, different coverages, different exclusions, ultimately different claims that were asserted by plaintiff. We represented two individuals and two corporations who were named as defendants in this suit. The principal defendant was a physician. One of the corporations was a medical professional corporation. The second corporation was a lay LLC, which owned the facility in which the practice was located. The plaintiff in this case sued our clients under multiple theories, but generally they fall into categories of medical malpractice, intentional torts, general negligence, and negligent supervision. There were two insurance policies at play here. One was the medical malpractice liability policy, which covered the physician and the professional corporation, and a commercial general liability policy, which covered the building and the other individual. We got involved in this case early, and we were able to posture the clients and take a position on coverage with both carriers with respect to the defense of the individual clients and the potential indemnification of the asserted claims. What we found ourselves with going into litigation was medical malpractice policy. They had accepted the defense of the professional corporation and one individual. They issued a reservation of rights as it relates to the intentional tort claims that were asserted by the plaintiff. But they agreed to defend and they agreed to indemnify on the medical malpractice claims. It's interesting to note that at the time, the carrier's position really was that they were pretty confident that there was not any real med mal exposure on this case because the conduct appeared to be intentional conduct outside the scope of professional services. At the same time, the commercial general liability carrier, they disclaimed coverage altogether, but agreed to defend the lay corporation and the second individual under a theory of negligent supervision, despite the fact that they strongly believed that there was no exposure on that claim. The result was that we got the clients into this lawsuit with all parties being defended by the two policies, where they did not have to pay their own attorney's fees at that point in time.
Right, and the general liability carrier agreed to defend under a reservation of rights, but then brought a lawsuit in federal court seeking a declaration that they had no obligation to cover, which was the manner in which we originally got involved in the case in the first instance. And it wasn't until later that the actual malpractice insurance company asked our firm to defend the other allegations and take over the case. It was still pretty early on in the case, but we wound up taking over the defense as well and negotiated rates with them and agreed to represent both the entity that owned the building as well as the physician who was alleged to have committed malpractice and or intentional acts.
Yeah. And the federal case was an interesting one because that carrier was providing half of the cost of defense of this case. The case went on for many years and ultimately went to a full-blown jury trial. The defense cost was exorbitant, and keeping that DJ action alive and defending those clients in that case kept that policy at play and kept that defense cost paid.
That is a strategy that we often use in our liability insurance coverage litigations. If you can force the insurance company to pay for the defense, a lot of times the rest, if you know how to keep the defense rolling and you know how to manage both sides, both the lawsuit for insurance coverage and the underlying liability claim. If you can manage them well together, you can often either get a lump sum settlement or get the claim covered, which is what ultimately happened here.
Yeah. What made this case particularly difficult was that the clients had assets. Both corporate clients had assets and the individual clients had assets beyond just the principal residence. If the plaintiff were to have hit for a large liability verdict against the individuals for uncovered claims, there was the real potential of the clients getting hurt here. Ultimately, we were able to get the intentional tort claims dismissed at summary judgment. And through the course of litigation, part of what we did was really educate the plaintiff's lawyer on what potential coverage was out there. And, without telling him what to do, lead him down a path of taking positions on behalf of his client that were not only helpful to him, but helpful to our position in terms of keeping coverage. And in the event that we got a liability verdict, it would be something that was going to be covered under one or both of those policies.
And that's something that we do routinely when we're in one of those liability situations, whether it's a general liability claim or a professional liability claim or any type of a claim. If we have access to the plaintiff and the plaintiff's counsel, most plaintiff's counsel want the money, right? And the best place to get the money is going to be through the race of an insurance policy. They don't want to have to go after uninsured defendants, even if there's a real possibility that the uninsured defendant is well within its means to pay an ultimate judgment. It's just much easier and much more in the underlying plaintiff's wheelhouses to deal with the insurance company, because insurance companies are in the business to pay these, to reserve these, to figure out the value. It's just part of their business model. And so we find ourselves very often getting involved in these types of cases where there's been a disclaimer or there's been an action brought by the insurance company, and getting the plaintiff to cooperate with us with the goal of ultimately resolving the entire thing, getting our client, the insured, out of their exposure, and getting the plaintiff to go away.
So in this case, going into trial prep, we had a demand of $15 million to settle this case. And we had $3 million of coverage available. And when I say available, neither carrier wanted to settle the case at anything even remotely close to policy limits. In fact, one of the carriers wasn't willing to put any money on the table at all. Once we impaneled the jury, as expected, the plaintiff demanded policy limits for purposes of potentially trying to establish a bad faith claim against the carriers for not settling. And that was a $3 million demand for both policies. When I went into the trial from both a theory and a evidentiary perspective, I had my eye on making sure that in the event that we were to be hit with a liability verdict, it was going to be a covered claim. And that's not something that the plaintiff's lawyer really thought about at all. And that gave me a distinct tactical advantage when addressing the jury. And I started as early as jury selection in voir dire, getting them tuned into what the case was about from my perspective, not necessarily on a defense verdict kind of argument. And of course, I go into the trial looking for a defense verdict. But I knew early on, I knew from the day we took the case that this was going to be a difficult case to win. And what we needed to avoid were the clients getting hit with a liability verdict that was not covered. So in this case, the malpractice theory was a difficult theory for the plaintiff. The negligent supervision theory was a little better factual theory. The way it ended up playing out, the plaintiff's lawyer ultimately focused on the harm to the client, which is understandable, and it was the strength of his case. But as early as voir dire, in my opening statement, in my closing statement, in every cross-examination, I focused on making sure the jury was looking at this as a malpractice case, not as a negligent supervision case. And it wasn't that, I'm not acting as a plaintiff's lawyer. I'm defending the case, but I was able to focus the jury on the claim that was covered and focus their attention on the evidence relating to the claims that were covered. The plaintiff's attorney, I don't think he really even knew what I was doing. I'm not sure he even cared until it was all over and he realized that what he ended up getting was a verdict on covered claims. But, these are sort of the nuances of trial practice that, perhaps not all trial lawyers think about or recognize. And the plaintiff's counsel was a very sophisticated, capable lawyer, but I'm not sure that he really saw what we were doing. And ultimately, in the jury instructions and in the special verdict that was given to the jury, it almost made a roadmap for them to make findings. If they were going to make findings in favor of the plaintiff, that it was going to make them on claims that would be covered under the policy. And ultimately, they did come back for the plaintiff, but they came in at considerably less than half of the policy limits, and it was entirely covered by the insurance policies at play. In addition, we were able to get the DJ settled, the federal court claim, where the clients were able to get back all of the attorney's fees that they had paid in defending that case.
So what's interesting about success sometimes, the success is ultimately how you protect your client. And we've learned over the years that the idea of simultaneously either prosecuting or defending a declaratory judgment action against an insurance company, while at the same time defending an uncovered or arguably uncovered claim or a claim that's being paid on a reservation of rights, puts us in a fantastic position to advocate for the client. And I always say it's great because you can say, ultimately, most of these types of cases, although it didn't happen in this trial, Matt ultimately had to try this case to verdict and ultimately was covered and paid by insurance, and the clients never had $1 of exposure for any of the indemnity and got back almost all of the legal fees they ever invested in the case. But most of the time what happens is the insurance company decides to settle with the plaintiff before you get to that point. And we're in a unique position to say to the plaintiff's lawyer, hey, your case has these 5 different problems and it's not worth nearly as much as you think, while simultaneously telling the insurance company, hey, you guys better get rid of this case because you have major exposure because you have these 5 problems. And it's a great way to advocate on either side to take what's really good about the case and beat up the carrier and take what's really bad about the case and beat up the plaintiff. And that's why the vast majority of these just get settled.
It is interesting being in a case where we're not coverage counsel. We don't have a duty to the insurance company per se. It creates an interesting dynamic in a settlement conference or in a mediation with plaintiff's counsel and with the court. When you get an insurance company to send an adjuster or send somebody from their claims department who has the authority to settle these things, you're not there representing the carrier. You're there representing the client. And their interests can be very different at times. And getting a lawyer who can navigate that is easier said than done sometimes.
Now, Matt, you were the primary trial counsel for the defendants, but the malpractice insurance company was the malpractice insurance company for the husband. And then there was the general liability carrier, which was really for the entity that owned the building. And the wife had her own lawyer, and he was present and involved in the trial. What was the dynamic like and the strategy vis-a-vis you and he both trying the case for defendants who are technically united in interest?
It's interesting. I had the husband, my colleague had the wife. I say colleague, he's no firm relation to us, but we had similar positions on the facts, but not necessarily similar positions on the legal theories. He was a panel lawyer for the CGL carrier. And
what does that mean?
Well, when the commercial general liability carrier agreed to defend the case under a reservation of rights, they contacted the client and said, look, you can choose one of the lawyers that we use all the time. And, we have agreed rates with them and they have some obligations to us and they're going to represent your interests and our interests in this case. And they did a nice job, but they were not necessarily out to purely represent her interest. They took the carrier's interest into consideration in strategic decisions that were made in that case.
And that's, an important lesson to be learned about whether or not somebody wants to get their own lawyer, assuming that they have the legal right to do so. That can be a whole nother discussion. Or whether they think they have significant exposure above policy limits and might want to hire outside counsel outside of the counsel assigned by the insurance company as a monitor, as an ombudsman, as somebody who makes sure their interests are protected. We've been engaged to do that many times, but today's trial story is an example of the importance of how that turned out very well for the clients.
Yeah, the lawyers representing the wife were good guys and good lawyers, and they contributed to the result that we ultimately got. But they were not quarterbacking the big picture of this case and how to navigate potentially uncovered claims and potentially claims over and above policy limits. They didn't deal with that at all. In fact, they wrote to the client and, as is customary, essentially said, look, it's very conceivable to us that you could be hit for uncovered claims or for a verdict in excess of coverage, and you can and should get your own counsel to advise you on that. And, when the client gets that, it's a little disconcerting, and it's typically, we get that all the time where clients come in sort of concerned saying, well, who do they really represent? And it's not to say that they don't represent your interests, they do. But, when there are potential claims that are not covered, or when somebody's looking at exposure that's above and beyond policy limits, it is worth getting a second set of eyes on it. And there is incredible value in having someone who is not beholden to the carriers to help you make those strategic decisions.
And let's not mistake the fact that there is an ethical obligation of a lawyer that is hired by the insurance company to defend the insured. The ethical obligation is to advocate on behalf of the insured, and that's what they're supposed to do. But there's an inherent obligation to protect the insured's interests, and there's also a sort of business conflict that can infect. And I'm not saying that it happens all the time or that it happens with great frequency, but when you are someone who gets all of your work from one source and you're concerned for whether or not you're going to keep that work, by definition, it creates a sort of cloud on your ability to think and process freely with nothing in mind other than protecting your client. And so it's not to be said that, these lawyers don't have that ethical obligation. It's not to be said that every time you get assigned counsel from an insurance company through your policy that you need to worry. It's just there are situations where it's appropriate for you to say, hey, maybe I should get at least a second set of eyes, as Matt said, on this, even if I'm not going to hire the lawyer and they're not going to go forth and be involved.
Yeah, especially when you're dealing with something where there's either a full or a partial disclaimer and they're taking the defense under a reservation of rights. That is not a scenario that people are confronted with in most claims or every claim. They're not outliers either, but when you have a claim that's covered and you're assigned counsel through your carrier, we're not suggesting that's not adequate or that they're not good lawyers or not doing a good job. They are both. However, when you're dealing with a situation where you've got complex claims, some of which are covered, some of which are not, where there are multiple policies involved, that's something that, the lawyers appointed or hired by your carrier are not necessarily in a position to advise you on the complexities of multiple, layers of coverage and which claims are potentially covered and not covered. That's just not something that they're going to do.
Right. Well, with that, I want to say thank you, Matt. Thank you for sharing that story. And thank you all for listening today. And if you like the podcast, make sure to leave a review and subscribe so you don't miss an episode. You can visit the Schwartz, Conroy, and Hack website at www.schlawpc.com for more information. I'm the insurance lawyer. Have a fantastic day.